Who's there?
D&D, of course, with Excuria International.
D&D as in Do Not Disturb?
Oh, no, this is Discourse and Disclosure with ECI.
Oh, you mean the one that's hosted by Ananya and Romit?
Bingo!
Welcome back, dear listeners, today to another episode of Disclose and Disclosure by ECI with Ananya and Romit. We've often spoken in the past about different and exciting pathways that one may take towards working in the field of ADR. Today, we touch upon an allied subject of how to leverage knowledge of a more diverse skill set, like, for example, experience in psychology, and use the same to your advantage while advocating.
Today we have with us Mr. Stephen Puchkov, a Russian qualified lawyer from the Moscow State Institute of International Relations. He also holds an LLM with distinction in international arbitration from the Queen's Mary University of London. An associate with the Russian law firm in the past, Mr. Stephen now heads his own boutique consult and advisory practice, namely psychology. We welcome you to the podcast, Mr. Stephen. Thank you so much for joining us.
Okay, thank you, Ananya. Thank you, Romit. I'm very happy to be here. Thank you for inviting me. So, shall we begin?
Absolutely. Stephen, the first question that I pose to you is definitely about this new venture that you've started, psychology. It's such an interesting concept. It's not your typical hard law, or very, in fact, law specific. Tell us more about what exactly is this initiative. Tell us more about how you came to work in this practice field and what is it exactly that you offer your clients?
Okay, a very valid question. Thank you. So I'm working between law and psychology. So I use knowledge about how people think, what inner concealed processes there are in our minds. And I apply that knowledge to dispute resolution to help my clients to be more persuasive at court or in arbitration or in negotiations, whatever. In fact, during my whole career as a dispute resolution lawyer, even before I started this venture, I felt that there was something more than black letter law. I felt that, judges, arbitrators do not make their decisions based exclusively on the law and the facts. But I could not shape that at that time. Luckily for me, during my time at Queen Mary University of London, I picked a course called Strategic Decision Making for Lawyers, which was absolutely brilliant. Well, Queen Mary is absolutely brilliant from all angles, and this course was not an exception. Among all other wonderful stuff, it discussed the issues of thinking, the issues of decision making. I elaborated on that. I went really in depth with this question. I wrote a dissertation on that topic, which was later published, and I ended up publishing quite a number of articles in good law journals worldwide. And so I decided that I could help other lawyers to be more persuasive in their job.
Thank you, Stephen. And I think that's an incredible resume with an academic bent of mind as well. What I'm wondering about is the idea of using psychology in the courtroom. How does it work in terms of oral advocacy? And what makes it different from, especially in the field of ADR, than pure litigation? And how is the LLM that you did that's affected your perspectives on this, especially with the shift towards a greater focus on psychology itself?
So I will reply your questions one by one. How exactly does it work? I should first talk about how I work, what I do in particular. My clients address me when they need, to have an edge in psychology as well as in law. And what I do, I review their submissions, both written and oral, and suggest some tweaks that could make those submissions subliminally more persuasive. Talking about how it differs in courts and in arbitration, yes, it does differ. For example, well, I'm not talking for all legal systems right now, but in my home country, in Russia, court proceedings are relatively brief and expedited, and judges have little time to listen to the parties. So any longish courtroom speeches are not welcome. Too long submissions, written submissions, I mean, are not welcome either. Whereas in international arbitration, arbitrators are very happy with long submissions. So in arbitration, I have relatively more space to apply my knowledge than in courts. Again, cases in arbitration are usually, on average, more expensive than in state courts in Russia. Cases I worked with. I think it is pretty much the case everywhere. Well, without prejudice to those very, very expensive disputes that do happen in state courts. And so the parties may be more interested in my services because greater amounts of money are at stake. Again, when the case is very expensive, the parties are more likely to secure third-party funding, which is, again, a very good case when it comes to my services, because in this case, the third-party funder pays for everything and for my service as well. And the party doesn't have to pay anything until it wins. And so the parties, are more likely to resort to my services in such high-stake disputes.
I think that's very interesting that you mentioned that it is third-party funding cases or cases with if I gather correctly, are high-budget cases, which do refer to your services, since it is, what I gather, a very niche practice area. It's a very unique practice area in the sense that we haven't come across a firm which does support and help different parties while drafting their pleadings in such a manner as to pay attention as to what would be the psychology of the judge. Can you share with us maybe an instance of how a pleading without paying attention on the psychology would work in turn of one that you may have supported by tweaking it and changing it to, well, of course, affect the psychology of the judge or an arbitrator?
Okay. My favorite example, it is very obvious, yet very difficult to follow. Many lawyers use a lot of negative language in their submissions. Like the other party says something which is not true because psychology teaches us that negative language with all these nots, no's, is poorly perceived. We sometimes subliminally totally fail to notice that there is a not. And what we remember in the end is all the same, but positive, without the not. And I routinely redraft submissions to leave these nots out. It is especially important for oral submissions because, whereas on writing, the judge or the arbitrator can go back, deliberate, and finally notice these notes. When he or she is listening to an oral submission, they have absolutely no time. Their mind is overloaded with this flow of information. And it is extremely important at this moment to be as persuasive as we can and to help them memorize what we want them to memorize and not the opposite.
So one important tip that I gather is not using negative connotations. Instead, maybe rephrasing it to sound or to make it more positive in your favor. Do I gather that correctly from what you're saying?
Yes, absolutely. For instance, instead of saying that is not true, you would be better off saying that is false, etc., etc.
So this is talking about written pleadings. Now I'd like to bring the conversation towards oral pleadings and actually arguing the case in front of this arbitrator or this judge who you definitely want to, of course, give the judgment or the award in your favor or in your party's favor. So what are the kind of tips or advice that you provide to your clients when it comes to oral pleadings? And what is it that they have to change about maybe their demeanor, maybe how they speak, maybe how fast they speak when it comes to oral pleadings?
Okay. In fact, I provide tons of advice and I won't be able to reproduce it here. You have made a good point about speed of the speech. It is known that people better perceive others who talk at approximately the same speed as they do. And for that reason, I might, in some cases, listen to recordings of the relevant judge or arbitrator speaking, or when it is a judge in my country, I might attend some of his or her hearings on different cases before we've got the right to attend court hearings here, unless they're closed. And I provide, I use a timer and count what number of words the judge or the arbitrator says per minute, and advise the counsel and in some cases train them to talk at the same pace. Another very important point to be mentioned, and again, it's easier to learn than to follow, how hard to push. Many counsel think that the harder they push, the more aggressive they are, the more successfully their case will be. This is not always the case, because on a subliminal level, all judges and arbitrators know that in most cases, there is not such a thing as a saint on the one side and pure evil on the other. And when what the judge or the arbitrator hears does not match this deeply held belief, they feel what is called cognitive dissonance. It is a very unpleasant feeling that occurs when our representations of reality does not match our actual experience, and it is a very motivating feeling. We have to alleviate it in some way, for example, by reshaping our beliefs or avoiding experience that counters our beliefs. So it's a separate point for a discussion. In a nutshell, the arbitrator, when he or she hears that one side, one party to the dispute is a saint and the other is devil, they feel this cognitive dissonance, and they may subliminally discount the facts, the evidence, the law the counsel is referring to. So, or even lose faith into what the counsel is saying, which is, of course, a bad thing to happen. So in most cases, it is beneficial to take a balanced approach, to fairly discuss all pros and contras, and upon deliberation, come up with a conclusion that probably the party I am representing has more grounds for their claim to be satisfied than not. So balanced approach is, in most cases, more welcome than a pushy and aggressive approach.
That was incredibly detailed in terms of steps that one can take to influence decision making. What I'm thinking of is very often, especially I think your website mentions this, that on the face of it, judges almost always have a decision in their mind. And it is always your job to very reluctantly convince them to change the position that they have, even when the case begins. So on the face of it, the role of a judge is to simply apply the law as it is. So when you go about influencing decision-making in this fashion, what are the kinds of ethical boundaries that you have to be aware of when doing this? And on a slightly lighter note, how true have you found this to be, that what a judge has for lunch influences the kind of decisions that they do take?
Mm-hmm. Again, good question. Thank you. Probably you have slightly misunderstood what I have on my website. I did not argue that, we have to make judges change their mind. No, sometimes we have to reinforce their opinion wishes in our favor. What I did right is, yes, that in most cases, a judge or an arbitrator will have some preliminary view of how this case is going to end at very early stages of the process, even before all the relevant evidence has been presented, before all the oral submissions have been made, which is probably not very good, because later it is very difficult for the judges or arbitrators to depart from that initial opinion. Now, talking about ethical boundaries, it is a good question too, because this sphere is very new and no ethical standards have yet been developed. I believe that they should be developed through practice that is that. On the face of it, one might think that using psychology to be more persuasive is somewhat unethical. I would not agree, because it is just the next step of advocacy skills. No one would argue that using a good counsel who speaks well is unethical, although this also gives a party an edge. No one would argue that wearing a suit in the courtroom rather than flip-flops and swimming suit is unethical, although a party wearing a suit will definitely have an edge as compared to a party wearing flip-flops. So the next point, I'm currently working on a case where my client hired me exactly because they thought that the other party can have an edge due to their personality, and they wanted to level the playing ground. So that's why I'm helping them now.
I think that's very interesting that you mentioned that, and it brings me to my next question. In fact, that how much of an influence do traits or body language or actions which one might just be so accustomed to that they don't realize that they're doing, say for example moving a pen or sitting straight up, not moving around, looking straight at the person, how much do these traits influence a person's or an opposition's thinking process?
That is something I do not do, not my sphere of competence. I work with cognitive psychology, and it's, a little bit different.
All right. Could you share with us a few tips on psychological behavior which one can inculcate in themselves to improve a particular aspect about them? So, how can, say, for example, how can I improve myself to be more convincing to maybe just even my professor or my peers or my family members? And what are these traits which I can inculcate in myself?
Good point. I think I have already mentioned two tips like avoiding negative language and applying balanced approach. But that is not about changing personality. Well, changing personality is in fact incredibly hard, and I don't think that this can be done at will. In a short time perspective. The bottom line is that I don't think there can be any advice in this respect. But you can change your approach to information you work with to become more persuasive.
Could you tell us a little more about cognitive psychology itself?
Okay. So, by way of reference, cognitive psychology is an area of psychology that deals with processes of perceiving information, storing it, processing it, and reproducing it. I see you, I interpret the rays of light that enter my eyeballs as two people on screen of my laptop. This is a cognitive process. For some time, I will remember your faces. At some point, I will forget them. That is also a cognitive process. That is not only about vision. Cognitive process is, working with all kinds of information is cognitive process. When you read a document and you, again, you see it. First of all, you see it. Rays of light are entering your eyeballs. You interpret it as letters. From your experience, you know that letters make words make sentences. You derive some meaning from those sentences. You somehow store them in your memory. Surprisingly, most often in your memory, they look not the same as they look on paper. So we do not memorize everything as it is. We do not even see everything as it is. So you somehow interpret them. Well, that is pretty much cognitive processes.
Thank you so much, Stefan, for that quick insight into cognitive processes and how we understand, interpret, and analyze the world around us at large. With that, we're coming to the end of this podcast session. So just before we conclude, I'd like to do a quick summarization of everything we've discussed today, a bigger toolbox for maximum lawyering, because we talk about how you can bring together skills from the domain of psychology to the domain of practicing law for becoming a more effective advocate for your client. This is, of course, in the case of Stefan, not just limited to alternate dispute resolution, but also extends to within the courtroom in terms of better oral pleadings and written submissions as well. We begin the podcast by looking at the question of synergy and how to bring these skills together. And we learn about, in particular, the strategic decision-making course offered at QMUL, Queen Mary University of London, which becomes the starting point for Stefan creating this niche for himself. We then look further into Stefan's practice, and he tells us more about the Russian system itself, wherein we learn people often approach Stefan in order to become more effective and have greater impact with a shorter period of time, because court proceedings in Russia are generally not the longest. We look at the kind of work he does and the consultancy he provides with regard to oral pleadings as well as written submissions. and the true depth of research that goes into this, which, for example, includes looking at the rate of speech for judges. The rate of speech is important because psychological research has shown that you are more receptive to individuals who match the same rate of speech or the speed at which you speak make an impact. With that, we then go into other questions of how to become more effective as an advocate and what are the skills to use. For example, we discussed what is spoken of very commonly in ADR, the effect of negative language, and the way positive phrasing can help have a better impact on individuals. Now that we spent some time on these psychological tips and tricks that we've asked for, we move to the question of ethics and exactly how ethical it is to apply these processes in any sort of negotiation, mediation, whatever it may be. The standard point of view here is, of course, that ethical standards should exist, and Stefan believes, and we agree with him, that these should be developed via practice. At the moment, however, this particular niche with an intersection of law and psychology is quite new and is looking for regulation indeed. After this, we go ahead and we also explore the idea of what cognition is. How do you understand cognition? And this is important because Stefan's specific focus is on using tools of cognitive psychology in order to influence other people in your favor. Simple things like posture, how do you sit, moving a pen. These are not things that are looked into, but it's a far broader holistic scope. Because as Stefan puts it, it's not possible to change your body language or personality in one go altogether. It's a very, very complicated task. What instead these skills of law and psychology help us do is refocus our attention towards how we process information so that we're better aware of the kind of biases or prejudices that we carry with us. And it helps us to read, understand, and then present our client's case in a manner that is most effective for our clients. With that short summary, I'd like to thank you so much, Stefan, for taking out the time and being with us here on today's podcast. We hope you enjoyed this experience. And to our listeners, thank you so much for tuning in. And we hope to see you again for our next episode.